Hello, this is a mini lecture on Newark versus Shore Realty, one of our cases exploring scope of liability under Superfund CERCLA, the Comprehensive Environmental Response Compensation and Liability Act, and in particular in the Shore case dealing with landowner liability. Right? So let me get out and show you some of my slides here. The facts here are relatively straightforward. Shore Realty and its owner, Donald Leo Grand, were interested in purchasing a parcel that turned out to be quite contaminated. There was an illegal hazardous waste storage facility on the premises. Careful investigation, actually, by environmental consultants found that there were 700,000 gallons of hazardous waste there, which would take somewhere around $650,000 to $1 million to clean up. Right, so you might look at this, immediately ask yourself, why on earth would Shore Realty want to purchase a property that's so heavily contaminated and has an ongoing illegal waste disposal operation going on there? And the answer actually may not be so straightforward, but I think hopefully should be understandable. The case itself, of course, indicates that Shore Realty and Leo Grand had hoped to get out of liability and having to pay altogether. But even barring that, even if they were somewhat liable or hit with some responsibility after they purchased this land, you're still left with a very, very valuable piece of property once it's cleaned up that, presumably if it's within a metropolitan area, you might be able to do a lot with in terms of development, right? So that is sort of part of the incentive here. Land, even if it's contaminated, may still retain significant value, especially once you can get it cleaned up, right, for development purposes. Right. So Shore went ahead and took title. Well, just remember, though, just before he did that, he actually tried to get a waiver of liability from the New York Department of Environmental Conservation. Didn't get it, but went ahead with the transaction. And unfortunately did not immediately then move to shut down this hazardous waste storage facility, which really, I think, ultimately was his downfall in the subsequent litigation. By the time the New York State officials inspected it, they found that things had gotten worse, and on January 5th, just a couple of days later, Shore then evicted the hazardous waste storage facility operators. Afterwards, it was determined that between the time that Shore had taken title and the actual eviction, another 90,000 gallons of hazardous waste had been deposited. Things had actually gotten worse. And so in February 1984, the state sued Shore Realty. Shore didn't take action or real action to clean this up, to address this until June, and in October then the U.S. District Court entered a adverse judgment finding Shore liable. And the question here ultimately is whether Shore is, of course, liable as a landowner and whether it might be entitled to some of the affirmative defenses. And the takeaways here, the U.S. District Court finds that Shore Realty is in fact liable as a current landowner. That is sort of what the statute intended, notwithstanding all of Shore's protestations that it's new, it wasn't responsible for those prior hazardous waste disposals. And that, in fact, the response was appropriate given that there was a release or threatened release that had occurred and therefore triggering the need to respond to this and allowing for the recovery of the costs of response. Leaking tanks, pipelines, leakage, seepage into the ground, leaking drums all constitute a release or threatened release. The last issue here, and that is whether the affirmative defense was something that Shore was entitled to, was a little bit more complicated. And I'll go back to the formulation. This is not language that I included in my earlier mini lecture giving this overview of CERCLA, but really quite important, and that is the third-party acts defense. If a release or threatened release is caused by a third party, then the landowner can get off the hook. Unfortunately, it's not quite that easy, of course, as Shore found out. Not only does the act or omission have to come from a third party, but the third party cannot stand in any kind of formal legal relationship to the defendant. And that is, the third party cannot be an employee or an agent or have some other kind of contractual relationship with the defendant or landowner, where that act or omission occurred as part of that contractual relationship, right? So it's a very narrow set of individuals, the parties that qualify. You have to be outside of that legal relationship of an employee, agent, or some other contractual relationship. You cannot be a part of that. If you are, then the affirmative defense does not apply. But if you stand outside of those relationships, then the defendant still has to have done some things. In particular, the defendant must have exercised due care with respect to those hazardous substances, knowing, taking into consideration the characteristics of the hazardous substances. And it also the defendant must have taken precautions against the acts and omissions of any third parties. So not only do you have to affirmatively do things, exercise due diligence with respect to the hazardous substances that you know of, but you also have to take precautions against the acts and omissions of third parties that stand in no legal relationship to you, right? So this is a very narrow affirmative defense, and it turns out, of course, that that Schorr did not qualify for it, in part because there was hazardous waste that was dumped by the illegal operation during the time that he took title and the time that he finally evicted those companies, those tenants, on January 5th, 1984. Essentially, the court said that Schorr should have foreseen that dumping would continue, that this was very dangerous, and Schorr did not take precautions against the foreseeable acts or omissions of that tenant that was engaging in an illegal hazardous waste disposal operation. Right? So the takeaway here is that landowner liability is very, very broad. Just because the current landowner didn't have anything to do, was not at fault with regard to the prior disposals, the way the statute is structured is that as long as you're the current owner, you are on the hook. And if you think about that, just by way of additional explanation, it sort of makes sense for creating a disincentive for current landowners simply to transfer the property to somebody else. As soon as you would do that, the new landowner, if the current landowner was not liable, you would be able to shed your responsibility. So it creates a disincentive to transferring the property because nobody in their right mind would want to become a landowner if you suddenly then get saddled with all those cleanup response costs. But in addition, also, the current landowner has all the rights of possession, and therefore, if they really didn't like the government coming onto the land and taking response action, might make life very difficult for environmental regulators. And so making the current landowner also legally responsible and liable essentially aligns the incentive of the current landowners to do as much as they can to clean this up, and aligns their incentives to cooperate with government regulators and others with regard to the cleanup. The final takeaway there was affirmative defenses are very narrowly drawn. The third party acts and omissions defense, very narrow and not easy to take advantage of. Right? I'm going to leave it there. Thank you.